Hi, my name's Laura Tilt. I'm a senior solicitor at Southern Waters Legal, and I have here Leona Bennett, who's our head of the family law team, and we're going to discuss today the issue of prenups.
So one of the things we get asked all the time is, what is a prenup? Can you have prenups in Australia? They hear about them on TV in America, but is that something that exists?
Yes, and we do hear that language a lot with prenups because, as you said, it's probably what people hear on TV. It's not the language that we use as lawyers and not in a courtroom. We call them binding financial agreements. Any or parties to a marriage or to a de facto relationship can have a binding financial agreement. You can come to that agreement or sign one either before a marriage, before you enter into that relationship. You can do it during your marriage or during your relationship, or you can do it post-separation as well. And that financial agreement talks about, or I guess discusses how the assets are to be divided between you, how your assets are going to be divided if in the event that you were to separate or divorce.
Yeah, okay. And what we do see with these agreements is that they take it out of the jurisdiction of someone else. So by entering into a binding financial agreement, whether it's in your premarital stage where you both want to outline what you think is going to happen with your assets in the event that you separate, or whether it's post-separation, it's a way of having a private agreement between you both that doesn't require Big Brother, being the form of the family court, looking over your decision and determining whether it's fair. And in a prenuptial agreement, or in a binding financial agreement, as we refer to them, sometimes there won't be the same element of what the court deems is to be fair, but it might be something that the parties have contracted to do. And that's why it requires both parties to have independent legal advice so that they know what their entitlements would be, and if they're going to contract out of those entitlements, that it's documented in that type of agreement. So I suppose that leads into the big question we get is, well, are they binding?
Yes, yeah, we get a lot of clients that come to us and say, look, I've got this agreement, we have signed it, is it binding? What can I do now? I've now separated and I don't necessarily agree with the contents in it anymore, or, am I bound by what is in here?
And I think probably the easiest answer is it depends on how good the agreement is and how it was drafted in the first instance. I had a gentleman come to me 2 years ago and he had a binding financial agreement that he spent a lot of money drafting with his previous partner. And the agreement dealt with one property in Hurstville, and it had its address, and it said, this property will be his, he will keep this property, she won't make a claim upon it. The problem was that in their 10 years of marriage, at year 5, they'd sold that property and bought another property that was not dealt with in the binding financial agreement. And as a result, it didn't cater for what he wanted to have happen, which was to protect an asset he came into the relationship with. So had that agreement have been drafted differently, and to say, well, who's going to protect his Hurstville property and or any substitution for it, and if they buy a property, they'll accept that what he brings in will be either quarantined or recognised in title, it would have created a much better scenario for him on his property settlement to try and finalise things. So I think really, are the documents binding? Absolutely. If they're done properly, I say they're the best insurance policy you can have, because if you don't have it, you have nothing, and you're in the arms of the court to make a decision. In particular, society at the moment sees a lot of second relationships, and those second relationships have children from their first relationship that's still floating around. And many of our clients who want to enter into binding financial agreements come to us because one of them has 3 teenage children, the other has 2 adult children. They've worked hard to retain the assets they've got, and they want to keep them for their children in the future, rather than it be a battle between their assets later on if they were to separate. So there's a real almost succession planning component to binding financial agreements in second relationships. It is the type of agreement, however, that I think it's imperative you have a specialist assist you with, and someone who works solely in the area of family law. They're very nuanced, they need to be done correctly, and they tend to take time because there are certain elements that you need to tick the box to make sure you've done all the things you need to do. To make sure that it's a valid and binding agreement.
And there's a risk there, isn't there, that if you don't have someone who knows the legal requirements that makes that binding, that in fact that agreement becomes not binding.
Absolutely. You spend a lot of money paying someone who doesn't necessarily or hasn't necessarily achieved for you what you wanted to achieve. And they can be really good agreements that offer you a level of protection and create a hurdle from your partner being able to then go to court and look to re-establish a property settlement. So I think the short answer is yes, binding financial agreements by their very nature are binding if they're done properly. And if you need any assistance in addressing a binding financial agreement during your relationship or at the end of your relationship or prior to entering a relationship, please do not hesitate to give us a call and we will assist you in any way that we can.